Well, good evening, ladies and gentlemen. I'm delighted to about human rights or rule of law on Southeastern Europe. It is part of the project Human Rights in the 21st Century, a project that is organized and coordinated by Novum Institute from Slovenia with a number of partners across Europe, across Southern Europe, Southeastern Europe and European Union, and it's supported by the European Liberal Forum. I would, at the beginning, invite the executive director of the European Liberal Forum, with whom this event would not be able to take place. Daniel Kaddik, executive director, please do tell us why the European Liberal Forum is supporting this project.
Thank you very much, and thank you very much for being with us today. Indeed, it is a very important project for us, this European Liberal Forum project, with the support of Novum from Slovenia and our good dear friend Sebastjan Pikl as the project leader. Why is it important for us? I would like to roll back a little bit for that to something that I discussed back in the day with my professor of law. And we discussed the issue of rule of law and human rights. And as you know, in the 1930s and 40s, there was rule of law that was applied, but it was contradicting human rights. And there was something developed at a later stage, it was called the Radbruch formula. Something that basically says, if something is so atrociously against human rights, it cannot be just. If there is a law that is not just, it cannot be. And this was something that was applied in the discussion about Nazi Germany. And that's something that should still guide us in our principles. If a law is unjust, it cannot be right. If a law is against human rights, it cannot be right. And as liberals always put the individual freedom first. We don't look at groups, we look at the individual, and we look at the well-being of the individuals, we look at the dignity and the rights of the individuals. That's why we have to have the discussion in this project that we have of human rights in the 21st century, of which we have the second round table today. So focusing on individual freedom, especially also when it comes to group interest, is in the core of the liberal belief, of the liberal value system. And that's why we think it's important, but especially as human rights seems to be something so normal nowadays, but with so many challenges ahead, like digitalization and other issues, especially in the wake of a new rising populism around the world, we would like to examine this topic as European Liberal Forum with our members, with our partners, and therefore we are very happy and privileged that we have Novum as our member, one of our 47 members all across Europe, with which we can implement this very project. So thank you very much, Novum. Thank you very much, our partners, and thank you very much for you tuning in today.
Thank you, Daniel Kaddik, Executive Director of the European Liberal Forum, who manages a number of projects related to human rights, rule of law, democracy all across the European continent. And as he mentioned, this project is coordinated and co-hosted by the Novum Institute from Slovenia in cooperation with a number of partners. From Novum Institute Slovenia, we have tonight Sebastjan Pikl, who is going to explain to us the importance of this project, Human Rights in the 21st Century. Sebastjan, the floor is yours.
Thank you, Emil, for the kind words, and also to Daniel. I will just somehow try to continue from where you stopped. Yes, this second event on human rights and rule of law is a part of the broader project which Institute Novum is together with European Liberal Forum and several other political foundations in European Union and beyond is now going to host for at least next 2 years. And as it was already mentioned, yes, human rights are a cornerstone, one of the cornerstones of European integration and one of its fundamental values. And human rights are currently being challenged by a changing political landscape, challenged by a rise of illiberal political systems and populist systems, and other complex issues which are deriving out of the technological progress, geostrategic interests, and most of all as well, climate change. And to add a recent global challenge on public health, coronavirus disease. It is becoming apparent now when the project is in progress that this coronavirus disease is going to impact hugely on our everyday living and definitely on strategic shifts and changes which are going to be quickly present globally, not just in the European Union. And as I said, there are some more issues like freedom of expression in this digital age, artificial intelligence, genetic engineering. All these issues demand to try them against or to push them against human rights idea and try to find out what or how are connected. These changes are connected with the issue of human rights in the 21st century or human rights today, as a matter of fact. This project is going to publish analysis, comments, data, reflections, and exchange opinions on such roundtables and digital events over its online hub, Human Rights in 21st Century. So do follow us on the internet, on our webpage and different social media. And posts are not going to be only from European Union, but beyond, from United States, probably, as it was maybe already mentioned, also Africa and Asia and so on. So we strive to go global at some point. So this event, the second event, is going to focus on Southeast Europe, its accession and its integration process. And it's going to be about scrutiny of the respect of human rights and rule of law, which are actually two cornerstones of EU integration. So once again, my sincere thanks to all speakers for accepting our invitation, despite demanding situation, and of course to the European Liberal Forum, and most of all to Emil Kirias, who made everything happen. He is a force behind the second roundtable, so thank you very much. And a bit, just for the end, a bit paradoxically, maybe this new online space, which is for some time now becoming our reality, can be turned into an advantage and maybe even bring our distances closer. So we shall see. Thank you.
Thank you very much, Sebastjan, for explaining very well what is the narrative of the entire project. And we hope that it's not going to be only what it's going to be encompassing events at the end of this year, but as it indeed tackles human rights in the 21st century, or as you said, human rights in the world we live in today, we hope that this is going to be continuous and that it's going to contribute towards a debate that is going to be ongoing between those people who believe in freedom, democracy, and human rights. And when we were discussing about organizing this event, we said that we are going to focus on the European dimension, in particular inspired by what is happening in Southeast Europe. There are important changes going on this year with the decision of the European Council to give a green light for the start of the accession negotiations of North Macedonia and of Albania, which we hope are going to happen by the end of this year or at the beginning of next year. That process in parallel happened with something very new. a very dramatic, one would say, in the functioning of the European Union, and that is the scrutiny that the European Commission does on the functioning of the rule of law, respect of democratic values and human rights in the member states, not only in the acceding countries, but in the member states. A report that was published now in September this year. Understanding that these two processes are extremely important, we wanted to launch a debate and have with us a prominent panel, prominent experts who are going to bring up the discussion about the human rights, their respect, in terms of respect of rule of law. Before we go into that discussion, I would like to invite somebody who perhaps has the best possibility to give us an overview on the importance of human rights in the world today. Somebody who has experience in national politics, in European politics, somebody who had been working in supranational institutions, somebody who still is very much determined in promoting human rights. That is Astrid Thors from Finland, who is currently chair of the Human Rights Committee of Liberal International, also being board member, bureau member of Liberal International as its vice president. Astrid Thors will explain us whether human rights as a concept is indeed universal, as the founding fathers of the United Nations said. Is it still a concept that brings and unites the humanity today? So Astrid Thors, please, the floor is yours.
Well, thank you very much, both the organizers and Emil, and it's so good to see all of you here. My dear predecessor, Markus, as chair of the Liberal International's Human Rights Committee, and colleagues like Vesna from ALDE, the ALDE Bureau also. Let me also first say that I'm very pleased about the project, Human Rights in the 21st Century, and it's very much, let's say, similar to the project we are doing in Liberal International on digitalization and human rights. We have had a couple of webinars, policy labs on these items, because I think it's extremely important to see that the freedoms and rights are not curtailed in the digital environment. Unfortunately, we see very much of that today, when instance for there has been lockdowns of internet in many countries, when protests are going on. We take Kashmir as an example. Of course, what is happening in Hong Kong is also related to lockdown. So that's very, very, very topical. We see challenges to the human rights system. But you know, when we are talking about, and when I'm looking back at my career also dealing with the European questions, sometimes, of course, it was asked whether what comes first, human rights or the rule of law. But actually, I think we have a trinity where we have human rights, rule of law and democracy, as Daniel was saying. One is meaningless if the others are not respected. And let me take some examples. One which I learned working with Liberal International. You cannot easily use the words rule of law in South Africa, because the apartheid used that word. So you must use a little bit something different, because you had rule of law, but not human rights for everybody. Or you can, if you talk about a very topical example, that you have access and rule of law in all kinds of questions, is the fact that in June last year, the Supreme Court of the United States, with the majority voting by the Republican judges, said that you could not challenge gerrymandering in courts. And this was also, I think, a principle that is a little bit, let's say, shocking for us here in Europe. And not to say that we have ample of beautiful constitutions with human rights, but they cannot be upheld in courts. So these, I think, three examples of why it's important to have the Trinity. And dear Emil, when you called about this event, I was so thrilled, because one thing which I love more than else is exactly the question of rule of law and democracy. I participated in drafting a theme number of publication that appeared some weeks ago here back in Finland. And you might see that you have Frau Justitia here in the picture. And so this is a principle I think as a Finn also is very much committed to. But I think it's important, as you said, Emil, to look at the origins and how universal the principles were, because now we hear that human rights is something that is a Western innovation, and especially a liberal one. I can say some about the challenges, because when we should remember that when the Charter of the United Nations was signed in 1945, and you had representatives of all continents, of different systems of states, there was both reaffirmation in the fundamental faith in fundamental human rights, and they committed the countries to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law should be maintained. So this we had in 45. And of course, also our dear fathers in the liberal world, in the Oxford Manifesto, they put down that no state should assume power which conflicts with the fundamental rights of the citizens. And then we had 10 principles. And these rights and conditions can be secured only by true democracy. So our insightful fathers in Oxford, fathers, very few mothers, Vesna, had that insight also. I can even go a little bit further back when Daniel referred to what his teacher had thought. When I opened the Finnish law book, on the first page, on the hard side, it was saying that a judge should never apply a law in such a way that it becomes injustice. This was the first rule for a judge for many centuries in Finland, Sweden. So, and as I say, we know that people around the world ask for this same principle. As Markus knows, as former chair of Liberal International, and with your all activities, you know what thirst there is for this work. And we also know that the authoritarian regimes, they do hate rule of law. They won't take the grip of the judiciary, as we have seen in Poland. They do, and we should talk much about it, should see how it is part of the authoritarian regime to undermine what has been universal principles, not only liberal principles, but we liberals have been the first promoters of that, but they are trying to undermine it. But I also think that we need to talk of two factors that I became aware of last week. There is actually a Pompeo-led International Religious Freedom Alliance, which is believed to have been promoting religious freedom, religious beliefs to the detriment of gender rights, rights of LGBTI. And it's so serious, these attacks on some of the rights, so that even the United Nations Special Rapporteur on Religion and Freedom of Belief made a report in March on all these instances where religion has been used to the detriment of other freedoms. I think this is also a tendency we cannot accept. Unfortunately, there is not a liberal party in India, only liberal individuals. But I think we should also note that presently there is going on a very serious attack against the freedom of association in India, where they are making the Indian version of what we Europeans know more about, the foreign agent land rights of Russia and likes in neighboring countries, but also very, very serious attacks on the possibility of civil society organization to operate, like we have had in Hungary. But I think we need to notice that and be paying more attention also to India. As I said, rule of law is something that is I'm so passionate about it. And we know also that Liberal International put down a declaration on better governance in reality of rule of law, and emphasizing, building on the Andorra Manifesto, that rule of law is really a precondition for building trust in society. And it means that authorities are equally bound by law as other entities in the society. Nobody is above the law, and politicians are especially bounded by these principles. It needs the independence of the judiciary and also access to justice for everybody in a fair way without too lengthy procedures. And we believe it's one of the best remedies against corruption, which deprives so many countries and people of their wealth. Dear friends, just some words about, and we'll come back to that, but as you said so kindly, Emil, in my previous work as an MEP and minister and politician here in Finland, I worked very much with the EU enlargement process. I sometimes do ask myself, did we pay enough attention to the principle of rule of law? And I would say yes and no, and I know that Vesna will come more into detail. It might have been easier to measure human rights or measure, that elections are democratic, but it was not as easy to measure the rule of law. It has come later. We have the Venice Commission with their checklist for rule of law, and as you mentioned, the EU latest scoreboard and report on rule of law. But really, I hope that we can find and clarify what we mean by rule of law, because we also know that there has been alternative think tanks set up to give a different notion of rule of law. And freedom of speech, in my mind, is also a very, very important part of human rights when we are talking about freedom, when we're talking about rule of law. Maybe this is enough as an introduction, and that we can see some of the challenges. And final words is, of course, that many countries have used the coronavirus as an excuse to install special procedures, special conditions, and so on, to restrict freedom, the freedoms and the rights of the people. And I can assure you that Liberal International has been trying to be as attentive as possible to that. And we also issued a statement to the UN Human Rights Council on that principle. And we know we have many friends in those areas. So thank you, Emil, for the floor.
Thank you very much, Astrid, for these inspiring words and for bringing us to the attention that even though our discussion and debate today will focus on Europe, in particular on its Southeast European corner, the debate about human rights, rule of law, and about democracy, it's actually a global debate. And even though we are going to focus our discussions on one part of the world, the phenomenon and the discussions have a global impact. You have mentioned that these two aspects are inseparable, the human rights and the rule of law. You actually spoke of the Holy Trinity. But the question that we posed perhaps is not even a dilemma at all. What comes first, human rights or rule of law? That's why we decided when we were creating this panel that we are going to have a debate by people who have a lot of experience in this area, people who are prominent experts and who are going to be able to inspire a debate. Let me present some of the speakers, or no, actually all of the speakers who are going to join us in the discussion now. Together with us, we have Judge Margarita Nikolovska, a Macedonian judge who is currently Vice President on the Constitutional Court of Bosnia and Herzegovina, having previously served in the European Court of Human Rights as its Macedonian judge there for 9 years. Not only that she was judge, she also has an extensive experience in the courts in North Macedonia, but also in the civil society sector protecting human rights. With us, we also have Ms. Vesna Pusić, a former deputy prime minister and minister for European and foreign affairs of Croatia, a prominent sociologist and a politician from her country who has a huge experience in the front lines of defending human rights, be it in the legal matters or fighting for human rights together with the civil society on the streets. She was, by no coincidence, Croatia's candidate for Europe, for the United Nations Secretary General. Together with us is also Tobias Flessenkemper, the current head of the office in Belgrade of the Council of Europe, a person who has an extensive experience having worked for international institutions, including the European Union and the OSCE in the Balkans, in particular in Skopje and in Sarajevo, currently being based in Belgrade. And of course, with us is Markus Löning, former member of the German Bundestag, and also former Federal Commissioner for Human Rights in the government of Germany, who has been serving politically in the bureaus of Liberal International and an ALDE party, and chaired the Human Rights Committee of Liberal International, now focusing through learning human rights and responsible business in bringing together the human rights aspect and the business community. So thank you all of you for joining today in what I believe is going to be an interesting debate. And even though we're going to focus, as I said at the beginning, on Europe and Southeast Europe, I believe at the end of the discussion, it will be also interesting to touch a little bit about what is happening in the United States of America and the impacts it has on the global and particular Southeast European and European politics. But before we go into the discussion and into debate about what is the core of our interest today, which is rule of law, human rights, European Union, its functioning, the accession process, opening chapters, monitoring, scrutinizing the governments, I would like to invite Tobias Flessenkemper, as I said earlier, who is head of the office of the Council of Europe in Belgrade, to mention something about the institution that he represents, believed by many to be the champion of human rights on the European continent. Tobias, why do people consider Council of Europe champion of human rights in the continent? Well, nowadays more and more people believe the European Union is the one.
Thank you very much, Emil. Thank you very much, European Liberal Forum and Novum Slovenia, for organizing the roundtable. And thank you very much for inviting the Council of Europe. It's not that often nowadays that people think of us, although Judge Nikolovska is here, who has been representing the Council of Europe and its values as a practitioner of the court. Often, indeed, the Council of Europe has taken a little bit of a second stage position in Europe. Although when we talk about Southeastern Europe, of course, all countries of the so-called Western Balkans, but also Turkey and Greece, Bulgaria, Romania, Moldova, Albania are part of the Council of Europe for many years. The latest joining is indeed Montenegro, who joined in 2007. So really, this is the family of where everyone in Europe comes together. Even Kosovo, where of course there is a special situation, has a very strong relationship with regard to the Human Rights Convention, as the Human Rights Convention is part of its constitution. So I think we have a reason to be there. Judge Nikolovska will say more about the court, so I'll move a bit more on the political side of why we should be there. Number one, the Council of Europe is in itself a strange triumph of human rights. These are actually the words of the historian Mark Matsova, who actually described how human rights suddenly in the 1940s, became the operating DNA for European politics. And that was a strange triumph. And it was against all odds. And it was actually against all odds that in Strasbourg, people came together and developed a methodology. And I would like to put this as a first point, the methodology of actually having multilateral treaties. To put this down on paper, it's not declarations, it's binding treaties. The Human Rights Convention is the first ever internationally binding human rights treaty with its own court, which functions as a very effective monitoring body. And of course, the character of this binding treaty with its court has two very, very important issues to it, values. Number one, the right of individual petition and the binding nature of its judgments. We'll discuss how binding they have been in the region, and we can also discuss on the individual petition. But both of them give us indicators why maybe we're finding ourselves sometimes in a different situation with regard to human rights, democracy, and the rule of law. The country I'm working in is among the top 10 of individual petitions to the European Court of Human Rights. And Serbia is by far not the top 10 in population in Europe. We have 47 member states, and Serbia is the smaller third of the member states with roughly 7 million inhabitants. But nevertheless, 1/10 among the number 10 numbers of individual petitions, which gives us an indication that something is not working with the rule of law sector. So here you have your link. The human rights issues come to the fore because they cannot be treated well within the country. So that's why we have a lot of individual petitions. But also the binding nature of judgments, and I'm sure we'll discuss this, is a very good indicator on how countries are actually ready to take human rights seriously. The second thing we're doing is obviously we cooperate with the countries. That's why we have an office. And this is exactly while we actually think it is coming together. Behind you, you see it in our two official languages, in English and French. It is exactly about these three core values. Now, talking about Southeastern Europe, I really like that you use the word Trinity, because indeed, the question of the Trinity has been a very controversial question between East and Western Europe. If you look a little bit theologically at the word Trinity, of course, the schism between Orthodoxy and the Western Catholic Church arrived very much about the issue of what was first, or was it all at the same time? So yes, indeed, from a Western perspective, if you take this analogy, there is everything very much interlinked, while maybe in some more Eastern political thinking, there is some sort of sequencing, indeed, of power and what comes first and what comes next. Now, from the Council of Europe point of view, things are obviously completely interlinked. Now, where do we stand with this actually on the practical scene? Maybe just to finish and not take too much of your time at this first round. Last week, we marked the 70th anniversary of this European Convention on Human Rights, and our colleagues from Greece, who had the chairmanship, proposed indeed a declaration to mark the 70th anniversary. And this Athens Declaration, which was adopted by the ministers of the Council of Europe, was very much looking at effectively responding to the public health crisis in full respect of human rights, democracy, and the rule of law. Now, it puts together a number of very important points: proportionality of measures, the public space, assembly, freedom of opinion, information, the role of science, etc., the use of technology, all of these kind of things. But what is also important is that not everyone among the 47 member states of the Council of Europe was signing up to this declaration. And that gives another indicator of where we stand with human rights. So actually, it was not possible for Hungary, Azerbaijan, and Turkey to sign up to this declaration. We hope that they will join this declaration soon, but it would be, of course, a very important signal for Southeastern Europe, not having these two other Southeastern Europe countries in the broader region, Hungary and Turkey, not signing up to a declaration on human rights today, which will make our work difficult. And maybe really the last element is about the interplay between the European Union and the Council of Europe. It's very interesting to observe that monitoring now comes in after the Council of Europe had worked on this for many years. And when we look at the monitoring reports, this is again an indicator how eager countries are to follow up. Let me give you an example from another member state of the Council of Europe, the one I come from, Germany. There was a member state, there was a report by the European Commission Against Racism and Intolerance on looking at racial profiling, a human rights issue in the police. And this was a recommendation made by the Council of Europe for many years. And it was actually Germany, and it has led to a big controversy in German politics if such a study on racial profiling by the police should be undertaken. And it was a recommendation of the Council of Europe, which was not taken up and has led to problems. Domestic political problems, but also, of course, to violations, because not enough remedies were taken in the police services. And this is where the value of monitoring and peer review comes in. And I think we need to be much more serious of really following up monitoring reports. And here for everyone. The Council of Europe is made out of the EU member states and 20 more member states. The EU member states have actually founded the Council of Europe, but they need to feel themselves equally bound by its recommendation. Astrid and Thors mentioned the Venice Commission, we have mentioned the court, etc. That kind of follow-up needs to be done by everyone. Only then it can actually unfold its transformative power also to those countries who are trying to join the European Union, and for which, of course, these criteria have to be measured against the requirements of Article 2 of the Treaty on European Union. So this maybe as a starting point from my point of view as an institutional representative. The institution is there. It has developed a methodology of standard setting, monitoring, and helping countries to move on. We have to actually look into an environment where things are not necessarily anymore decided in consensus, like last week in Athens on the declaration on the 70th anniversary. But also we have to be very clearly looking at the cooperation between the European Union and the Council of Europe in a spirit of really taking up and following on to the recommendations that have been made. Thank you.
Thank you, Tobias. This was really super interesting to listen. And even though I worked for the Council of Europe, it was mind-opening for some points that you brought up and bring us to the reality of what is happening in the Council of Europe today. You mentioned the European Convention for Human Rights that is there for 70 years. And you also mentioned the Athens Declaration. So basically on the 70th anniversary of the European Convention of Human Rights, which established the court in Strasbourg, it's perfect to have with us Judge Margarita Nikolovska, who actually was working in that court, considered by many in the world as the most prominent institution that judicially protects human rights. Judge Caca Nikolovska, you served there for 9 long years before you became a judge in the Constitutional Court of Bosnia and Herzegovina. Something that Tobias mentioned in his previous intervention was, I think, very important. He mentioned the words binding and the word for everyone. Now, would you say that the national and international legal mechanisms that exist do really provide protection for human rights in Europe in a binding way and for everyone, and in particular in Southeast Europe, where you come from and where your focus is on the work? Judge Caca Nikolovska, the floor is yours.
Thank you very much, Emil. Let me first express my thanks for the invitation to speak on this occasion. The rule of law within the relation with the fundamental rights was, it is, and it will be subject matter of interest and a lot of discussions. As we saw with the previous speaker, freedom is mentioning all the time for something. On the other side, rule of law, and not always these things are going together. Not because in theory is not like that, but I think that in practice sometimes somebody is fighting for rule of law, which actually did not protect always the human rights. That's why I consider that Council of Europe as an institution from one side and the European Court of Human Rights, it's really something which shows in practice that it is an instrument and it is a very productive mechanism for protection of human rights. I would like to mention something about the practice of European Court of Human Rights, the case law of European Court of Human Rights, how this actually practice and the case law is sometimes implementing within the national courts in the countries, especially within the constitutional courts in the countries, which is not always, or better to say, it was not always accepted at the very beginning, which is not now the case. Now I think that the constitutional courts, especially in former Yugoslavia, they accept very much the case law of Strasbourg Court. And I like it very much because my experience, for example, now from Bosnia and Herzegovina shows that this is the way how to diminish the number of the cases within the European Court of Human Rights, just to allow to this court to deal with the very important and very specific and sometimes more, I should say, more important issues which could deal with the cases and that particular case law to be implemented in all other countries. Binding, it was mentioned. That's true that, I mean, the judgment and the decisions are binding for parties in that particular case. But I would like to say that actually the case law could be used by all other countries in a way that they are able to assess on one side, to consider the principle, the standards which are mentioned in that particular cases within their own country. Which means that it's not only for the national courts, as well the constitutional courts, but I should say that it's as well very important for all institutions in the state to follow the case law and to implement in their depending applicable way. The parliament to think about the quality of the law, which is the standard from European Court of Human Rights. We have no time now to discuss all these issues, but all standards, all principles could be used by all states body, of course, including the courts as a last part of the domestic remedies that the parties could use. So that's why I consider that European Court of Human Rights, it's really something which present the best mechanism of protection of human rights. We have a lot of cases from where each country could extract what is necessary for that particular country and use that. I would say several examples, for example, grounds on discrimination. We have a lot of problems in Macedonia to put in the law sexual orientation as a ground. And we fight a lot with these problems because we had even some professors on law, even some doctors who were very much against this. I do not like to mention the church, but these coming from the science were very much against this basic, about this ground. But we managed somehow, because of the case law, because of the convention, although it's not sexual orientation as such mentioned in the convention, but the practice, the case law of the court shows that this should be a ground. So I will repeat myself maybe several times, but I really found that European Court of Human Rights, it's really the institution which have to be respected very much by all countries, not only in Europe, but I would say outside of Europe, just to think the link between European Court as international court, the national courts, and constitutional court, as we used to say that European Court of Human Rights is European Constitutional Court, together with the Venice Commission as a really very prominent body dealing with the rule of law, dealing with the quality of law, all these elements shows that there are international mechanisms which could be used by the national mechanism to improve the human rights, not only as a protection, but as well within the legislation, which means to respect the rule of law. I would mention as well something which probably would be a problematic one within this now corona epidemic. For example, in Macedonia, we had a very unique probably situation. We had no parliament because there were the elections. On the other side, the president of the state introduced several decrees like laws. And these decrees later had to be somehow accepted by the parliament. Still, we have a problem with this, how to say, law, legal approach to these things. And I would be really very, very interesting to see if somebody will apply to European Court for some problems with the freedom of movement, with the discrimination, because some of these decrees touch all these questions, to see how the court is going to react on the question of prescribed by law and in accordance with law, when we have no parliament, but we have only executive power, which means government and the president of the state, but not any kind of intervention by the courts, neither constitutional court, until now, no regular court. So, I mean, I would be able to speak a lot on this point, but I will stop here. And if there will be some other discussion, I'm ready to discuss and somehow to explain something from the practice. What I would like very much to present and to see that I'm very satisfied with the Article 46 from the Convention about the binding elements of the judgment and decision on one side, and on the other side, the work of the Committee of Ministers to the question when the countries are not very willingly to execute and to implement the judgment and the decision of the court. This is really something which is a very strong mechanism, and it is something which is monitoring somehow from the Council of Europe, I mean Committee of Ministers, and the court, because in certain cases, Council of Europe could, Committee of Ministers, sorry, Committee of Ministers could ask for better explanation of the judgment, which the state is not willingly to execute or to implement. And this is very, very strong mechanism, because we had until now, and still we have some states which are not willingly to execute and to implement the judgment and the decision from the European Court of Human Rights, which is really very big.
Thank you, Margarita, very much. You mentioned that it's actually very good on one hand that a number of countries, in particular in the region of Southeast Europe, in former Yugoslavia, are taking the case law of the European Court of Human Rights and implementing it in its own judgments, be it on a constitutional court level or Supreme Court level. But also you brought up a question that is very important about whether certain states are willing to implement the judgments and the rulings, which brings me up to Vesna, who basically served as Deputy Prime Minister and Foreign Affairs Minister of Croatia for a number of years. And before that was coordinating from her parliamentary role the integration process of Croatia to the European Union. And exactly in this process of integration in the European Union, there was a larger scrutiny where the states are more obliged to follow whether the national aspects of human rights protection or the rulings of the Human Rights Court in Strasbourg. Now, Vesna, based on your experience, would you say that joining the European Union helped actually Croatia to improve its human rights record in a sustainable way? Or was it just ticking up boxes for membership and then going back to business as usual?
Thank you, Emil, and thank you, everybody. This is really very interesting, and Astrid actually kickstarted our debate so well with this Trinity concept. And I will just comment a little bit on that. We somehow all assume that all these three things come together: democracy, human rights, and rule of law. And it would be great if they did, and they should. But in real life, they actually don't. And you very often have, and I will give one example, you have the populists, also in Europe, also in the European Union, who have mastered the democracy aspect by convincing their own citizens that winning elections equals democracy. In other words, that once you won elections, you have the right to do whatever you want. And a lot of people, a lot of citizens actually accept that. The problems with the rule of law have already been mentioned, and I think the example you gave is very much case in point. Apartheid in South Africa was rule of law, but rule of awful law. And you can always bring abominable and despicable, pass despicable legislation, and then claim that following that legislation means rule of law. So I would say that human rights, this is the only, and by the way, the European populists, I think, are very close to figuring out that part too. So the real canary in the mine are human rights. Not because they're more important than these other things, but because they're more telling. You cannot fake human rights. You can fake democracy, you can fake rule of law, but human rights you can't fake. And if the legislation reduces rather than increases and extends human rights, it's bad. We always, in the early days, thought we can rely on civil society, not anticipating that civil society will also be groups that will fight for taking away human rights from different groups in the society. That civil society can be a form of totalitarianism from below, so to speak. And this is why this sort of rule of thumb of human rights, are they being protected and expanded and inclusive, or are they being reduced and certain groups are being excluded or have their rights reduced? I think that is sort of the constant litmus test, the constant indicator of whether things with the rule of law and democracy are going well, or whether these concepts are being misused, meaning democracy and rule of law are being misused for cover-up of different, more or less intense forms of, you can call it dictatorship, you can call it authoritarian regimes, or you can call it what is John Keane calls it despotism, sort of even scarier. But in other words, some kind of abuse of political power, mostly, by the way, mostly gained through elections, not through coups or something that's obviously undemocratic, but actually through elections with a little bit of control of the media, a little bit of scaring the opposition, a little bit using the legal system to eliminate competition, but in the end, by winning elections and then doing what you have persuaded people that you have the right to do, whatever you want. This is why this concept and this practice and this personal experience, if you want, of human rights is so important. To come back to Emil's question, what happened in Croatia? For Croatia, by far the most useful part of joining the European Union was the process of joining, was the process of negotiation. It altogether, from the ratification of the Stabilization and Association Agreement, it lasted for 12 years. And in many ways, those were the best 12 years of our lives. We were getting better. Slowly, the accession process also, I have to, by the way, a small footnote, I have to say that this was happening between 2001 and 2013. It was a different world. In many ways, it was a different world. It was a world before Brexit, a world to a large extent also before we started negotiations before the economic crisis. It was a world before Trump. It was a world before the pandemic. A lot of things. It was a world before China decided on a very proactive, let's say, not to use a stronger word, international and foreign policy. So it was definitely a different world. But under those circumstances, one of the things that was important for us, it changed the agenda. It changed the topics that we were discussing. It wasn't, what happened in the war. It wasn't ethnic relations, Serbs, Croats, Bosniaks, and all of these things. It wasn't identity politics. It was much more the boring issues of the 30-something chapters that we were negotiating in. The size of, I don't know, chicken coops, the types of nets for fishing, all kinds of things that are part of this negotiation process and of these chapters, which for a country and the region of Europe where identity politics has been all the rage for centuries, I would say, was very healthy. It was very healthy because it was demanding and boring. You couldn't, if you fought over some of these issues that were part of this lengthy book of rules that we had to integrate into Croatian legislation, it was on very technical terms. So this was one, I would say, big advantage. But not all the things, some things, of course, disappeared with membership itself. I'm very glad that they have now introduced or reintroduced this idea, which I think has already appeared sometime in the past, of this judiciary scoreboard or evaluating member states, not only candidates, but also member states on the judiciary. I think this is really very important. So some things, there was some backsliding, but some things stayed. For instance, and I can illustrate this with how that's developed. For instance, as part of our joining the European Union, Croatia had to pass a law on national minorities. That law guaranteed representation, guaranteed 8 reserved seats for minorities in Croatian parliament, guaranteed representation of minorities in the municipalities where minority citizens lived, in their executive bodies. It also guaranteed state financing for cultural activity of different minorities. One thing that came out, this is still obviously functioning, and this is still on the books. One thing that came out of it that, for instance, today, by far, the best quality weekly newspaper in Croatia is the weekly that is published by the Serbian Cultural Association, let's say, or it is called the Serbian National Council, which is an organization of the Serbian ethnic minority in Croatia, but with privatization of newspapers, of the printed newspapers in general, getting into trouble and having problems with financing. This newspaper managed to attract first-rate, the best journalists we have in Croatia, who are not Serbs, who are Serbs, Croats, I don't know what, no idea what they are, but they're not of one ethnicity. And they're producing the best weekly, the best paper we have. And that, in turn, created a completely different influence of the, in this case, Serbian ethnic minority, where they have a civic type of influence. They're people of a specific political profile or a specific political preference that read these newspapers and engage in these debates that are, again, of all different ethnicities. So it became, from something that was started as, let's say,
imposition.
Not an imposition, as a support for a minority, for an ethnic minority, became actually support for specific political opinion. In a way, from the Serbs, let's say, it's serving, of course, also that community, but it's also serving, let's say, a liberal democratic audience that reads this paper and that publishes there and writes there. So to make a small reference to this age-old discussion, collective rights or individual rights, and we as liberals, of course, should always stand for individual rights. However, in our countries, some collective rights are a sort of precondition to gradually come to a point where this will not be an issue anymore, and you could just stand for individual rights. Ethnic minority rights are a case in point. And with this newspaper, you could see how that sort of protecting, and this was definitely a result of Croatia joining the European Union, how protecting collective rights of one ethnic community actually gradually migrated towards a sort of civic issue or towards making a civic statement, which in effect should be our objective. Objective should be that in the end, you don't need to protect collective rights, only individual rights, because people are not discriminated against based on any of their sort of characteristics, such as gender, ethnicity, sexual preference, age, etc. So this is one example. The other example is Commission for the Prevention of Conflict of Interest. This was something that also came with the Croatia joining the European Union. We didn't have it, we didn't know about it before that. But when we joined the European Union, we had to establish a commission for the prevention of conflict of interest. is an extremely interesting example and case how this works, because the Commission can fine officials from all levels, from municipality level to the president of the country, can fine people, I don't know, not very big sums of money. And they never have fined anybody very big sum of money. But the actual fact that somebody was found, and this is published, of course, and publicized, that somebody was found, an official was found to be in conflict of interest, is considered extremely embarrassing and shameful. So people are, including, for instance, our prime minister, was fighting tooth and nail not to have a case where he was involved taken up by this Commission for the Prevention of Conflict of Interest, because just association with it and the possibility that you will actually found to have been in conflict of interest, that was about using, by the way, the government plane to go to a party conference in Finland of the APP. He was fighting like anything, like it was the biggest court on the planet. And it's not even a court. It's, maybe he would have to pay like 500 euros or something. It wouldn't be anything dramatic, but just this fact that, he would somehow be associated with that has, created such a status or odium in the society that politicians are very, very uneasy or scared of being somehow found in the wrong, let's say, because it's not court, so you're not guilty, but in the wrong based on the decision of this Commission for the Prevention of the Conflict of Interest. Another thing that was the result of our joining the European Union is the creation of the office of the Human Rights Ombudsman, or let's say People's Ombudsperson, because we have an excellent ombudswoman at the moment, who, the moment she criticized anybody, the government is up in the air. But luckily, the legislation that is based on the rules that we had to follow when joining the European Union is such that they can't remove her before the end of her term. So she is protected and therefore pretty outspoken about things that once they're in the open, it doesn't even matter if the government or an official denies it, because it's one of those things. Once it's in the open and it has been said, it's there, and people know if it's true or not true. It's just that before that nobody dared say that, but now there is the for instance, that's a third result. The fourth result, something that's very topical at the moment globally, peaceful transition of power after elections. We thought that was our problem in the Balkans, in Southeast Europe. As we can see now, we have been taken as an example by bigger and mightier nations than us. But in the meantime, our joining the European Union has made that a normal thing. In the 90s, this was not a normal thing. In the 90s, for instance, we had this example of the election for the mayor of Zagreb, of the capital of Croatia. And at that time, the law was such that whoever was elected mayor had to be confirmed by the that time president, Tudjman. And since the opposition won the elections, Tudjman at that time didn't want to confirm any of the proposed candidates for mayor. And actually it was a scandal, but you know, not such a big scandal that the results of the elections were not recognized. In the meantime, nobody even thinks in those terms. The peaceful transition of power on all levels has been established, and I would say that this is something that's taken for granted in a way, or taken as a matter of course. And finally, one thing that is indirectly, I would say, the result of our membership in the European Union, and a combination of, let's say, the legislation, but also somehow the culture, the political culture that you gradually move into or grow, that grows on you. And this is that for many years, Croatia was celebrating anniversary of reintegrating territorially the whole country in the 90s. This was done now in a way, this was of course very important for Croatia and for all of us, but at the same time, at that time, between 150,000 and 200,000 Croatian Serbs left Croatia, or were pushed out, or were scared, or were results regardless of why it happened, but definitely left Croatia and went to Bosnia and Serbia. These people were never mentioned, and the fact that they suffered there was never mentioned during these celebrations. And for the first time this year, our Prime Minister, who, by the way, is not from my part of political spectrum, but from the right-wing political party, went to these celebrations, and for the first time actually mentioned that and said that you know, we celebrate that because we reintegrated our country, etc., but we have to remember that there were people who also suffered in that process, and there was injustice done, and things like that. These are, I would say, all consequences, some very, you know, some institutional, and some in the realm of political culture, but consequences of Croatia joining the European Union, and they stayed. Thanks.
Thank you, Vesna. Quite insightful information, which I think is going to be very important for those of us who are those of the viewers who are watching now or going to watch later, and are going to wonder whether this entire process of European integration did matter, in particular when it comes to the respect of human rights and the establishing of rule of law. And it gives us a good opportunity actually to move on to Markus Löning, who did not have to go through this process of joining the European Union. And he did not have this experience in his political work, either in the Bundestag or being the German Federal Commissioner for Human Rights. But as a matter of fact, a lot of people forget that Germany had its own specificity, that it had to integrate a good part of the population which was indoctrinated by a communist regime for over 50 years. And for nearly 50 years, and it had to bring that part of the population into the system of functional liberal democracy. Now, Markus, what is very interesting to understand, given you live in Berlin and you have that all experience and wealth in yourself, how much did this German particular experience was useful when you traveled across the world, be it Eastern Europe, Turkey, South Asia, or elsewhere, when you promoted the importance of national or European mechanisms of protection of human rights?
First of all, thank you very much, Emil, and thanks a lot for inviting me. That was a fascinating debate, and it was fascinating to listen to all of you. And Vesna, I remember coming to Zagreb when I was a member of parliament, and we were discussing how do you How do you make judges independent, and what kind of system do you need to set up to, create an independent justice system in a country that doesn't have that tradition? And that was something that, Emil, as you pointed out, was really the German experience, is that you had the experience from German fascism, that was before I was born, but then you had the experience of an authoritarian regime in part of the country. And I must say, when the wall came down, for me, as someone that grew up in West Germany, I grew up in Luxembourg, I lived in the Netherlands as a kid, that was a completely new world. I felt stranger to people speaking the same language that I did in East Germany than to people in Belgium or Holland or in France. I felt closer to these people because that was my cultural and political world that I came from. So there's a tradition of living in an open society, in a free society, as long as I can remember. I was born 1960, so all of my life I had the great joy of living in free societies. And I very much liked what you said, Astrid, about this trinity. Maybe I wouldn't call it trinity because it sounds a bit Catholic to me, but still, it's human rights, rule of law, and democracy. I think they very much fit together well, but there should be a fourth partner in that, and that's an open society. It's citizens that should also be part of that equation. And when you were talking about it, made me think actually of Winston Churchill, when he was saying democracy is the worst form of governance we ever, that you can think of, except for all the other ones we had before. And that very well expresses, I think, the imperfectness of what people create, what human beings create. And we have imperfect systems like human rights. It can always be, this right or that right that should be added or spelled out in a better or more precise way. Rule of law can always be improved, the independence of the judge, the funding of the court, the number of employees, the system. There's always something that you can improve on the rule of law. And the same is true for democracy. We're fighting about the numbers of seats in parliament in Germany at the moment. You look at the US, what their fights, you look at the UK with their first by the post system. So there's always things to improve. And I think that's the very nature of things that people, men, human beings create. They're never perfect. They're never done. It's always a process, and it's an eternal process of improvement. And that's only the, let's say, institutional side of it. If then on top you look at the, let's say, reality, the real life side of it, it gets even more confusing and puzzling. I remember traveling to Bucharest when Romania was in the process of becoming member of the European Union. And of course, we were there and we were meeting all sorts of people, and we were meeting the head of the European Union delegation to Bucharest. And so we asked him, so what's your assessment about the current situation, about the rule of law in Romania? And he said, well, there's two things I have to say. Last week, or the week before last, there was a member of parliament from Italy that came to Romania. He talked to people in the judicial system, he talked to NGOs and civil society. He came back to me and said, yeah, actually it's okay, they can join, no worries. A week later, a member of the Swedish parliament came to see him, and he talked to similar people. He came back to him and said, it's awful, no way they can join. They're nowhere near being ready. And I think that, it tells you something. It's situations are different, but also views are different. Realities, the way we perceive them, even within Europe, are so different. And what may look good for an Italian colleague, looks a lot good for a Swedish colleague. So we have to take this into account, that none of the things we create are ever perfect. They always are in a process and need to be improved on a constant basis. We constantly need to work on them. They go forward, they go backward. Vesna was very polite about her own country. I think at the time when you were accessing you made enormous progress. And I could see that there was an enormous, a lot of energy and will to move forward, as I've seen in Romania and Bulgaria as well, you know, but none of it was perfect. And once the membership was there, a lot of the energy went somewhere else. But that's the way things are. And all the other Europeans were aware of that. Nobody said it, but obviously, you know, there was an element of political decisions. We wanted you on board. We wanted you to be part of the club because you are. And I think that's something that we need to take into account now, also setting up this new, what's it called, Rechtsstaatsmechanisms. I don't even know the English term for that. I think it's good to have it. And I think it's good we take a clear look and a clear assessment of what situations are, but we should never forget the historic and the context of where we are moving. And let me maybe focus on the question of civil society, because I think it was, who mentioned, I think it was you, Astrid, saying, you know, they can, or it was you, Vesna, yeah, they can go the wrong way. Yes, that's what we see in front of, I see that in front of my door in Berlin, you know, these guys that are obviously not, they don't want democracy. They don't, you know, they're not democratic. Or they are democratic in a way that, you know, once we have the majority, nobody else will have anything to say. And so there's an underlying condition about rule of law, human rights, and also democracy. And that's an understanding, a wide understanding of civil society, that we need to sustain it. If we look at the US in the moment, where you see a president undermining democracy, not by actually destroying institutions, but just by public speaking, by publicly undermining the credibility of institutions and processes. And if you look at the numbers in the polls, you see that a vast majority of his voters actually believe what he is saying. That's alarming, because that shows how easily democratic processes and institutions can be robbed of their credibility and robbed of their legitimacy. And so my real fear in the current situation is that there's not enough people standing up, especially those people that are from a background as I am, as I was pointing out in the beginning, that have been living in the free part of society or a free part of Europe all of their life, people that have democracy, rule of law, and open society in their bones. And obviously there's lots of them also in other countries, also in East Germany or Poland or Croatia, wherever, but this part of society is not standing up in the way we should. We're leaving too much space to populists, to movements like we see in all of our countries that say, well, there's no corona, and you know, this fake news and all of this stuff. And we are maybe not aware of the danger this really means to our countries. And that is something that that history could teach us, is that these kind of movements are so dangerous not because they have such great ideas, but because the rest of society does not stand up against them. And that's something that we need to do urgently. And then we can preserve, you know, all the imperfectnesses of human rights, rule of law, democracy, and so on. Thank you.
Can I come in?
Absolutely. Yes.
You have been so. You have been so. You have been so. So inspiring.
You have your glasses as an expert to comment, please.
You have been so inspiring, all of you. And I would have a page full of things, but I think the most important is to add to what Markus said. You know, the dangers that we see at present. And there was one of the policy labs around Liberal International's virtual congress. where we had invited as a moderator, or it was some of these labs, where Todorace from the chair of the Artificial Intelligence Inquiry Committee in the European Parliament, the Romanian person, who said, we can never have too many discussions on fake news, because in the present society, through fake news, through the conspiracy theories that you are making allusion to, there are efforts to undermine democracy. And of course, we must design the legal rules in a way that there's a balance between rights and obligations on the different parts of the social media. But finally, it comes back to education, that we have good media, free media, and good education of people who can see through fake news. There's not any quick fix for that. I this morning had a look at the EU Commission's compilation of fake news in Eastern Europe. And they were talking about, Kremlin media has said that 1.8 million so-called dead souls, we remember Gogol through that, had been voting in the American elections. And I hear ordinary people here in Finland repeat that same things, So that is, and we have a challenge as democracies to fight fake news. And then we have the geopolitical challenge, because it's not only Russian media, which maybe we have learned to see where Russia today, implicitly we can see that is that, or we can see how the yellow vests have been portrayed in Russia in a way with totally fake way. So to spread that there is more unrest in the liberal democracies than what it is in reality. So and Iran, Turkey, others are coming. So, but saying that, it was so nice to hear you also, Vesna, because I remember the last words of you in the Finnish Parliament when you were talking about the Croatia's accession to the European Union. You said that somebody asked, why is it? It is for the good of the country, the processes you are going through, and we were talking in those years. But may I come back to also what was said about minorities, and what you said, Vesna. I must say that in the positions I have been working as OSCE High Commissioner and in other places, I could not refrain from the conclusion that for minorities in Europe, 3 words in the Copenhagen criteria were the most important. When a country to accede to the European Union had to respect human rights, including the rights of minorities. I think those have been the 3 most important words for all kinds of minorities. However, may I say now, with 2 persons from with background in Skopje, you can also see that there are some countries with kin minorities that are misusing them and are not treating, they are asking more of their neighbor outside the European Union to do in the accession process than they themselves have been doing. I take, for instance, Bulgaria as a case, where they are not accepting the decision by the court in Strasbourg that also organizations with, let's say, minority descent should be accepted as working in Bulgaria. But then they are asking other things. So there's, I think today you have a situation with overzealous, misusing countries are doing a disfavor for minorities. That's, unfortunately, we see that, and Hungary is, of course, that is also part of their way of doing things and creating instability in some instances.
Astrid, just as you're mentioning this, and you mentioned you were OSCE High Commissioner for National Minorities, which is one of the key posts for protection of human rights that OSCE has. Do you have a feeling that the problem of the respect of human rights or minority rights was bigger in Southeast Europe than elsewhere, given your experience as a High Commissioner?
I don't think you can give a general answer, because every country is difficult. And of course, our reverend judge here, I would think that you would be able, for instance, to say something about the famous judgment of the European Court of Justice, the Felis and Sinci judgment, and whether it is implemented in Bosnia Herzegovina, or you could have some. I think I would not say that there's maybe more understanding that boundaries have been drawn in a way that is not following, let's say, patterns of minorities. I would say, but there are more, let's say, situations that demand the attention than in general. And I think when we look at human rights problems in general, I think we should not forget that the biggest minority in Europe without rights is the Roma population. And there we can see that throughout the years, the European Commission, we as parliamentarians, we as activists, we have been trying to do much for the population. We have been asking for strategies. I could notice in Romania, the strategies had been put on the shelf. Or you can see what is the situation for the Roma minority in Slovakia. So the disrespect in this regard is big in many countries, but it's not any better, for instance, in Holland, where they do not accept that Council of Europe reporting mechanism is talking about the Roma population. So that is, I think, a general trend. And then we have, of course, Russia, which Margarita would tell them also that they are now having their constitution, that they can, if they want, they will disregard the decision of these courts. And what's the situation in UK, where they want to promote more their sovereignty? Are they ready to follow the judgments? And Margarita, with all due respect, maybe there are, some people say that the decisions of the Committee of Ministers in the respect, when viewed to the respect of court decisions, that these discussions have become more politicized in the last years. And finally, we have also a very, very critical situation, also due to the same countries that, some of the countries that did not want to accept the Athens Declaration. They blocked the nomination of all the 4 heads of institution in OSCE. So since end of July, there is no High Commissioner, there is no Secretary General of the OSCE, no head of ODIHR, Office of Democracy and Human Rights, where Mihail Link used to be also the head, our friend in the Bundestag, or representative of the freedom of the media of OSCE. Also, that is kind of blocking some of the mechanisms that are there to promote democracy or have insight into what is happening in the countries.
Thank you, Astrid.
Can I
mentioned something that concerns the implementation and of the rulings of the European Court of Human Rights, and it's perfect that we have with us Judge Caca Nikolovska, who was there for 9 years. You could not judge on the Macedonian cases itself, right? A judge cannot judge the cases from their own country of origin, but you could deal with cases from all across Europe. And knowing your work, I remember that you were swamped with cases, reading until 3 o'clock in the morning, at home, at sofa, like cases and stuff like that. Did you have a sense that in the southeast of Europe, there were more problems, that the governments were less lenient to comply with what the rulings would be? Astrid mentioned the case of Bulgaria, mentioned the case of Bosnia, but also, I mean, there are issues, open issues in other parts of Europe. What is your sense?
First of all, I would like very much to thank to Astrid that she mentioned all these cases, because they are really problematic cases. And these are the cases from which we could extract that not always European court judgments are welcomed by the states. You mentioned Sejdić-Finci. It's true that, I mean, they present, I mean, Bosnia and Herzegovina, they present that there is a wish to implement the judgment, but actually always they found some problems, and these problems for me as a practitioner, as a judge, are not relevant. I would say that if they would like, they could implement and execute that judgment, even not only to change the law and the constitution, but within the election process, they could somehow implement the judgment. It's the same with Bulgaria. You mentioned, I didn't like to mention that case because I'm coming from Macedonia, but there are several judgments from European Court which are dealing exactly with the minorities' rights. And Bulgaria always avoid to implement, to execute this judgment on a way that they found always some kind of, I should say, political reasons. For example, they changed the number of members of some association, in a sense that if they fulfill that number, they are going to implement the arguments of European Court of Human Rights, which are nonsense. And they have some kind of repetitive cases in this area. But unfortunately, still all these problems exist, and they are not even they do not think to change something in these relations. And this is really very, very bad situation and position. But that's why I mentioned this Article 46 in the case where the Committee of Ministers, they have now the right to ask the court what they meant with that particular judgment. And if the court is going to find that there is a violation of paragraph 1 of that particular article, it's for the Committee of Ministers later to find a kind of political decision to punish, so to say, the state which is not willing to execute that judgment. On the other side, Russia was mentioned. So I think that showing this kind of force is not acceptable within a democracy, within a rule of law, within the human rights and freedoms. But it is like that. So I think that there are still some governments which are giving a kind of information. This was, if I remember well, your question. That's true. But the question is what kind of information they present to the court. I mean, the observations are always full of argumentation or presentation of something. But I would say that the court should organize more fact-finding missions in these cases, just to find the solution by themselves. I've been in a fact-finding mission in Turkey with hunger strike, and what I have seen at that time in Turkey, it was unbelievable. We had a more clear picture of the situation. So I really would like to support somehow this instrument to be more used by European Court of Human Rights. I know that it's not easy way to organize this, but in certain countries where we have this kind of repetitive cases, not only on minority rights, we have another as well problematic situation in Hungary, we have some problems with Poland. So I think that it's useful for the judges. It's useful for independence and impartiality in a judiciary, not only on the national level, but as well on the international level. I have that experience in Bosnia and Herzegovina. We have one picture presenting by the national judges, but international judges, they are asking something which is, for example, for the national judges, clear picture, but not for us. And with this discussion, actually, we put them to find the real argumentation or to find the real facts, what happened. In Bosnia, there was a problem with some religious beliefs and celebration. And within the Republika Srpska, it was such an attack to the international judges, unbelievable. And when I react on that question, I've been said by somebody else, you did not ask the president to react on this or that. I mean, me being a judge for such a long period, to put myself in a position to ask the president of the court whether I should react on something or not. Sorry, I mean, I am a practitioner, I am not a politician, and I will never follow this kind of reason. You mentioned something about some other options within the behavior of the government. There is something which I should say that went to the good direction. It's a reasonable time for dealing and finishing the cases. Introducing the national mechanism in certain countries, it was a good solution because within the dealing with that problem, they use the case law of Strasbourg Court, and they diminish very much the presentation, what means reasonable time, what means within what kind of elements and evaluation they could use on the national level. So nowadays, I think that there is no such a big number of cases from this point. The question of independence, impartiality of the judges, it was as well very well presenting not only by the case law, but as well Judicial Council in Council of Europe was dealing with this question, and especially the European Association of Judges, and as well supporting by the International Association of Judges, they put a lot of attention to this question, and I think that some standards were accepted from everywhere. It's not a perfect situation, but at least now we have some kind of standards which could help us to recognize the situation in certain countries concerning the impartiality and independence of the judiciary. There is that question was raised in Macedonia, it was raised in Serbia, Bosnia, Kosovo. It's still something which relates to Serbia's situation, but if you divided these two situations, you could see a kind of not being able to assess the situation, because in Kosovo still there are some problems with the international judges being involved in certain courts. So I would put aside Kosovo, but as well Montenegro, Albania, with the vetting system, we face the problem in a sense that it was accepted by the Venice Commission as a kind of good approach to deal with impartiality, corruption, and independence of the judiciary, but now they face the problem with the election of the judges. Nobody applied for the post in the constitutional courts. Could you imagine now what kind of situation they face with? And when we discuss in Macedonia the question of so-called vetting, I'm not very fond of vetting, but of a kind of assessment of certain judges, yes, because we have to show that independence and impartiality is something which is not only within the democracy process, but as well rule of law and fair trial and everything. So it is something which we have a kind of elements, but not always these elements are good for certain countries, but not good for the others one. So this is something which certain countries misuse the situation, and they are giving to the observation within the courts cases very different assessment and very different approaches. So the practice is, yes. Yes,
can I follow up on what you were saying? Because you mentioned a number of issues that go beyond the borders of the countries, that have more of a regional dimension. And actually wanted to follow up with a question to Tobias, because his role is head of an office in Belgrade of Council of Europe, which is a country-specific office. At the same time, you have experience of working in Skopje and in Sarajevo. What the judge was saying now was that there is need for more fact-finding missions, let's say from the Court of Human Rights, and then there is also need for more kind of parallel ability to check the situation in different countries and see the progress. Can Council of Europe help, or does it help in having this kind of regional approach in assessing the functionality of the mechanisms?
Oh, thank you. I mean, let me take it from the other side, this question. We talked a lot about the Council of Europe, and I'm grateful for this, but it also shows that we need to engage more in the Council of Europe. I will come to your fact-finding. Number one, we need more coordination by those who are defending human rights and rule of law in the Council of Europe. We have not seen it with the election of the new Secretary General, where 2 EU candidates were put forward, and we have seen it in the election, which has been postponed now, of the Deputy Secretary General, where the EU presented several handful of candidates. So we need to actually use these institutions, because others who may have different intentions are using them very forcefully. And they're trying to actually undermine mechanisms by rendering them illusionary. As Ms. Thors has said, you can, of course, pretend that you take care of judgments, monitoring reports, etc., but you do not provide the data, or you adopt a law which is actually non sequitur, without any difference. There has been an argument made with regard to retaining a very big country inside the Council of Europe, which was made by my government from Germany. I mean, not my government, but my government, the government representative from the country I know best. They said, like, yeah, but they're implementing court judgments in that big country. Yes, they may be implementing court judgments with regard to financial indemnities, but they're not changing structurally the situation. So this needs more profound engagement in the only place where these things are legally binding, and where they are discussed regionally at the level of the region of Europe, multilateral treaty. There are no multilateral treaties in Southeastern Europe, not a single one. The only agreement that has been formed in the last 30 years is there have been agreements they have been joining, like the energy community, CEFTA, etc., but they have not themselves done something. So we need a multilateral framework. We have it with the Council of Europe. I think there needs to be engagement. Let me also be a bit institutional on this thing. There is no legally consolidated system inside the EU on these questions of human rights and rule of law. Following Solange 1, Solange 2, Solange 3, German constitutional law from Karlsruhe, that there is not a state character of the European Union. The only constitutional and court structure that exists is the Council of Europe. And that is being attacked by non-implementation of judgments, by rendering maybe the monitoring processes which are there. And I'm very grateful to Judge Nikolovska's proposal of failed missions, etc. We of course like it, but they have to be wanted, invited, and followed up. And when we look at monitoring, and that's why I gave you an example from Germany, I think the monitoring reports, take something like fight against corruption. They need to be followed up and taken seriously. Again, I'm taking an example from Germany. Germany was criticized for 15 years during the enlargement period by Greco for not ratifying the UN Convention Against Corruption, but was walking around the German government saying that you should fight corruption. And these kind of approaches, which are not harmonized, which are not doing exactly as you say, means that others can come in and then blame the double standard metaphor, which has been used since the 20th century. They can use and fraction the approach, etc. So I think we have to be extremely serious that those who created the Council of Europe have given a beautiful tool. The Council of Europe was enlarged, giving the benefit of the doubt, but now is a time of hard work. Not all the 47 are always of the same view and not always of good intentions. And that then requires, for instance, also the engagement at the level of the Parliamentary Assembly, where we have seen a decline of engagement from the EU member states. And that in turn has a problem of the legitimacy of the court. The judges are being elected by the Parliamentary Assembly. So if we have a shrinking quality of parliamentary delegations in the Parliamentary Assembly, it cannot be without an effect at the long run on also even the credibility of the court. And there we have to really look at the system and be very precise. I'm very much like everything that is being discussed in the EU. I think we encourage, for instance, also the EU acceding to the ECHR, the European Convention. But let's not talk only about declaratory and illusionary things. The European Union is not able to currently do a so qualitative. It would need to have unanimity in the 27, while we have things there. And if you look in the Council of Europe, the 13th of July Council conclusions of the European Union make it very clear that on the Council of Europe EU cooperation, that much more is going to be used from the Council of Europe because it exists. It doesn't need to be negotiated. We don't need to talk about a rule of law mechanism if you have a court, but now be careful and protect the court. And maybe as a last one, why it is so important to defend institutions, it's because we have made the historical experience. Take, for instance, the International Labour Organization Convention Against Slavery from the late 20s. It was there, but it never prevented Stalin or Hitler to put up slave camps. So things can go back. This is an extreme case, but other things can go back. And I think some of the speakers mentioned the backlash with regard to gender equality. We are seeing this in the work on the Istanbul Convention. We have seen it also with the work on sexual orientation and gender identity, that there are backlash being produced, but we also see it on the rule of law agenda, which is much more complicated. I will not go into this in detail here, but of course, rule of law is a very complex thing. It is situation bound, democracy is time bound, and human rights may be sort of there forever, but still they're evolving. And for this, maybe as a last element is, was mentioned, open society. I think freedom, culture, education is indeed essential. But again, we have seen a disinvestment in this. We have seen a disinvestment in multilateral discussions. Take the example between Northern Macedonia and Bulgaria. This is about history teaching. Council of Europe had history teaching as a working field since the 1950s. It was abandoned in the austerity. 200,000 euros, cut it. But now countries are left alone, but you cannot solve this bilaterally. You have to discuss it multilaterally. It makes no sense. Talking about Macedonia makes no sense to discuss bilaterally, but also it gives a protection to discuss about these things in a broader sense. But it also, history and education is important when we talk about human rights and rule of law. How has rule of law developed? How has human rights been enlarged? How are we talking about this in schools? How are young people talking about this? And that would also help us to put some borders to information disorder. And I've shared with our technical colleagues, I don't know how to do it differently, in the Zoom, a link to a very important study on information disorder and what Thors mentioned as fake news, etc. But it's a very, very important field. And again, if you open it, you will see that even our founders in the Council of Europe, they have talked about exactly this when they drafted the convention. Article 10.1 is freedom of speech, And Article 10.2 is a reduction or the limits on freedom of speech. And it's the only article you find in the European Convention which has these two sides. So let's get to work.
Tobias. There's so much to be said. And it's true, this debate is really something that is in the very core of what we have to talk about when it comes to human rights in the 21st century. So even though we are supposed to finish in 3 minutes, I'll go a couple of minutes longer because I just want to ask a couple more questions. We talked about multilateral mechanisms. Tobias was mentioning it now, that the European Court of Human Rights is the only one that is by the German Constitutional Court seen as legitimate in this particular case, but the European Union has progressed in that sense, establishing the Fundamental Rights Agency in 2007. It's based in Vienna. Vesna, you were from all the panel, the last person who participated in the Council of the European Union in your capacity as a foreign minister and deputy prime minister. Encourage us, does this Fundamental Rights Agency brings any benefit to the respect of human rights in the European Union? That would be motivating for the citizens in the Western Balkan countries to basically aim to adhere to the European Union, knowing that the Fundamental Rights Agency, supplementary to the European Court of Human Rights, will improve their lives in terms of human rights protection? With your microphone on, because we want to hear you.
I actually forgot that you wanted to hear me. All of these institutions make sense only if there is a political will behind them. And at the moment, we have a problem in Europe. We keep referring to, in the European Union, I would say, we keep referring to European values. But at the moment, we have a real struggle on the value issue, and those values also include the importance or lesser importance of human rights. And that is the struggle between the populists and the liberal Democrats. And this struggle is going on within the European Union. So for the candidate countries, it's, of course, that makes it way more difficult to define what to expect. Also, for everybody who's been in the European Union, it makes it difficult to sort of decide where is this ship sailing to. And Fundamental Rights Agency, it's interesting, mentions 3 groups of rights. I think freedom from discrimination, access to justice, and protection of personal data. If you compare that with the rights that the Council of Europe is mentioning, 16 different rights, including freedom from torture, freedom from death sentence, freedom from unlawful arrest. In other words, you can see right away that the Council of Europe is dealing with, let's say, since obviously it's a way bigger group of countries, with more basic rights and with rights in societies and in countries which haven't yet reached, let's say, the something that we would consider an consensual or acceptable level of protection of rights. So you're basically fighting for your life and for the rights to well, sort of survive in these environments. Whereas Fundamental Rights Agency is more, I would say, showing the direction in which the concept of rights is developing. As somebody has said, of course, rights are a changing category. And, you know, in the Middle Ages, the right not to be burned on the stake as a witch would have been a very important right. Today, let's say that right might not be so important, but some other rights, because it's self-understood, but some other rights became more important. So obviously it's a changing category, and with Fundamental Rights Agency, you enter into an assumed higher level or more sophisticated level of rights protection, or to be precise, more sophisticated rights, like, for instance, protection of personal data. In many ways, so this is obviously important if it's true. At the moment, for instance, for some countries like Belarus that are members of Council of Europe, protection of the, it isn't a member? Well, but there definitely protection from torture would have been is a very important right. However, in some countries like, well, Hungary, Poland, Slovakia, even Croatia, in some aspects, things like rights of or equal rights for the Roma population, or rights to access to justice, rights to access to education of, for instance, Roma population, are extremely important. And they're still in the category of the rights that are basically protected by the Council of Europe, and are, in a way, the earlier stage, let's say, of rights than the ones that are seen as fundamental by the Fundamental Rights Agency. So we can all aspire to be in this category, but we have to take care of the basic rights as defined by the Council of Europe first.
Thank you, Vesna. Very, very important knowledge and understanding, because I mean, we have to understand that there are different layers of protection and there are different possibilities for the citizens. Just one short little question, Markus, because we talk about states, we talk about the rights of the citizens. You mentioned something which is very important, and some others mentioned it as well, the role of the civil society in ensuring that the human rights are being respected, and then the rule of law is being, I mean, the democratic rule of law is being imposed. In this sense, you work a lot with the businesses. Can we bring into this debate in a more organized, in a more substantial way, the civil society and the business community?
Absolutely, we need to do that. What you can, very much like what Vesna was saying about political will. Institutions and also laws will not work without the political will, which at the end of the day means the support of the people. And business obviously is part of our society and is not very engaged in political debates usually. But with the whole debate around sustainability, about more corporate responsibility towards society regarding topics like climate change, or topics like also labor standards in supply chain and so on, you see that business is getting a new role, because that's what people expect. They expect businesses to behave more responsibly towards society. And I think they can be a great asset in the human rights debate and in the open society and democracy debate, because they have something to say, and they have a vital interest in open societies, in democracy, in rule of law. Rule of law is a business interest, a core business interest. You know, that you can rely on what a government decides, that you can go to court, that you can get a judgment, and that you can rely that the judge is independent. So I think we should get people from the business world a lot more into this debate, because they will be great supporters to quite some extent for open societies, also for open borders. because that's what business is about. It's about open borders, about trade in goods, but also in ideas and in being creative, in being competitive across the globe. So we should get these guys more on board to add to the debate about democracy and human rights.
And I will just connect it to something that Astrid said. So basically, I'm coming back to you, Astrid, at the end for something you brought up, and now we discussed it a little bit with Markus, the business community, fake news, human rights, protecting the people. In the business community, we have Facebook, Twitter, and all these huge corporations, which basically have a massive impact on the way we live, on the way we organize ourselves, and on the way our rights are being protected in the society, in the way that the rule of law functions at the end of the day. Do you see a space for teaming up with these companies and the larger aspect of civil society?
Well, I think we first, a little bit going back, we first believed and saw when we had the revolutions in Northern Africa, that social media would be promoting democracy, and we were very, very optimistic. Then you have seen how, let's say, the big platforms have not been transparent with their algorithms, how they are working, and that really you create bubbles inside society, and there's not oversight with that. And I think there's going on very many interesting procedures where, for instance, Facebook has created new oversight board, and there is an alternative real Facebook oversight board that's trying to see and ask for what are you taking down as fake news, and what are you accepting, how are your algorithms working, are they working to direct you into a certain direction. I think here is an area where the international civil society is extremely strong, and I hope that this project and the Liberal International project can work together to see what would be the demands on the platforms. Of course, there are also liberal voices saying that we have given too much power to this big, and maybe that there is a room for states to regulate. However, we need to be very, very careful, because some of the things people want to regulate are, company, let's say, secrets, and on the other hand, not to give in to some authoritarian regimes who, of course, wants that the internet is state regulated. So you have a new kind of a discussion ground, and it's calling it battleground, but this is a very, very important area. And I would say, as a liberal, one of the most important things is to increase understanding, increase transparency, but not to put draconian responsibilities on some of the companies, because they will then give maybe the reason for Turkey and others to take themselves to the same kind of responsibilities.
Well, thank you, Astrid, and thanks to all of you for actually being actively involved in this discussion. I have to be honest. When we planned it at the beginning, and then we said that we are going to have an event that lasts for 2 hours, I thought that we were a little bit overly optimistic, and that we are going to finish early. But what I really find impressive is that I do have a sense that there is so much power among all of you, including myself, that I want to ask more questions and go more into depth and more into discussion, because there's so many important issues that need to be tackled, not only for ourselves who are part of this panel, but particularly for those people who are watching, and in particular those who understand that we need to do more in order to protect democratic rule of law for the citizens in the region of Southeast Europe, but also everywhere across the world. Yes, I also want to use the opportunity to congratulate the Macedonians for qualifying at the European Championships in football, because human rights is not only about talking, but it's also about what the real people matter, that it's important for them. As I was getting notifications now, stop talking, focus on on sport. But I do believe that the last comments were very important because it connects to something that this project will discuss on the next panel, which is on the 24th of November, and that is human rights and artificial intelligence. Very much related to how we progressed into that direction from the implementation of the judges to what is that can be done together, to the fundamental rights agencies that Vesna explained is going on the next level of human rights protection, the work with businesses, and what Astrid finalized, how the algorithms are working and how they're going to determine our future. So I thank you from the heart again, and I will hold up to the words of Daniel and Sebastjan that once this COVID crisis is gone, we are going to be able to meet in person and continue the debate, not only among ourselves, but also for the benefit of everybody who watched. Thank you very, very much for allocating your time and for being with us. And for everybody who is watching, I hope you enjoyed and you get inspired by this debate where we try to bring more women than men, unusual for most of the panels. Thank you very much.
Bye-bye.